Ranam, great to have you with us. Today we dive into the Special Allowance Supreme Court case, Chinmay Majumdar versus Paschim Banga Gramin Bank. I am Priyanka Chakraborty, joined by co-host Nesha Bhattacharya.
Together, we are going to untangle this massive high stakes legal and financial showdown that's currently unfolding across several states in India. It's a complex legal battle between the banking establishment and nearly 8 lakhs retirees.
And it is playing out across multiple arenas right now. We're looking at a situation where the very definition of a single word in a compensation package could dictate the financial survival of senior citizens who built India's banking sector.
To get to the bottom of this, we've told together a really diverse stack of sources for you. We're looking at official Supreme Court of India records, a completely fresh Calcutta High Court judgment from as recently as February 2026.
And we also have official circulars from the All India Bank, Pensioners and Retirees Confederation. They go by the acronym AIBPARC.
Also, we're looking at a recent detailed synopsis by leading YouTube content creator Shri Amiya Mishra.
It is a fundamental battle over how compensation itself is defined.
Specifically, we're going to focus on a highly controversial carve-out known as the special allowance and the severe real-world impacts this categorization is having on senior citizens who are just fighting for their basic financial security.
And the human element is absolutely the best place to anchor this discussion because without it, we are just wading through a sea of legal jargon.
Right.
The AIBPRC's June 9, 2024 letter to the Finance Ministry highlights the severe financial strain on retirees, especially the rising burden of medical insurance.
The medical insurance crisis is really the sharp end of the spear here. When you look at the baseline fixed incomes of these pensioners, any fluctuation in essential costs can be catastrophic.
And the numbers outlined in the document are just staggering when you track the progression.
Yeah.
Back in 2015, the introductory medical premiums for bank retirees were relatively manageable. They sat around 7,454 rupees for retired officers.
Right, and about 621 rupees for award staff,
which is the industry term for the clerical and subordinate employees who essentially form the backbone of branch operations.
Right?
But the letter points out that today, that premium has skyrocketed to over 101,000 rupees per year.
And that explosion in cost has had a devastating and frankly quantifiable fallout. According to the union's data, the system holds roughly 800,000 retirees.
Wow, 800,000?
Yeah, but the number of people who can actually afford to stay enrolled in this medical insurance scheme has plummeted to just over 100,000.
Nearly 7 in 8 retirees have been priced out of healthcare, forced to drop coverage when they need it most. The squeeze is now so severe that they've taken the entire banking sector to the Supreme Court.
Well, the catalyst actually traces back to November 1st, 2012, with something called the 10th Bipartite Settlement.
Right.
An industry-wide deal created a special allowance by shifting part of basic pay into a new bucket and excluding it from superannuation, denying employees rightful benefits.
So by moving that money into the special allowance category, the banks artificially lowered the baseline number that retirement benefits, specifically pensions and gratuities, are calculated against.
If pay is 100 rupees and 20 are moved to a special allowance, the pension is calculated only on the remaining 80, cutting lifelong benefits.
That is a huge hit. Over a decade of retirement, that missing 20% compounds into a massive financial loss for the individual.
Yeah.
And the retirees argue this was a deliberate illegal maneuver to shortchange them.
And alongside fighting that baseline calculation, the retirees are also demanding what they call pension updation.
Yes, they want their pensions routinely updated to match the standards set by the Reserve Bank of India, the RBI.
IBPRC says banks mishandled demands and even filed a false affidavit in the MC Singla case, sharply escalating the dispute.
Right. The union alleges that the IBA submitted documents falsely denying that provisions for pension updation even existed in the 1995 Bank Employee Pension Regulations.
Which is a very serious claim.
We aren't judging the affidavit itself, that's for the courts. But the allegation shows how deep the distrust runs, with retirees accusing the Banking Association of misleading the judiciary to avoid paying them.
Which is why the retirees clearly decided not to wait for internal resolutions. They took the banks to court state by state and they actually began securing significant legal victories.
Yeah, when you synthesize this wave of high court judgments, a very clear legal philosophy regarding worker compensation emerges.
It really does.
Sources highlight key wins, including Kerala High Court's Murali Mohanan ruling that excluding the special allowance from pension calculations is legally wrong.
The court essentially rejected the bank's artificial compartmentalization of the employee's salary.
In the Uttarakhand High Court's Baburam Kashyap case, the court allowed both the special allowance and dearness allowance to be included in pension calculations.
Yeah, the DA.
Exactly, they allow the inclusion of both when calculating the final gratuity payout.
And just for context, a gratuity is a lump sum paid by an employer to an employee at the end of their service. It functions as a reward for long-term loyalty.
Standard gratuity calculations often use 15 days of wages for every year worked, right?
Usually, yes.
Yeah,
The Rajasthan Maruthaharam Gramin Bank case, which reached the Supreme Court, underscores a statutory protection that sharply boosts payouts for long-serving staff.
the ruling says these allowances must be added to basic wage and mandates an extra 45 days wages under statute.
Essentially, a month and a half of pay.
For every year of service beyond 30, staff are owed a major extra payout. Someone with 35 years should receive 5 years of enhanced benefits, but banks refuse to honor it.
What's fascinating here is the specific legal mechanism the Supreme Court uses to determine what actually counts as pay in all of these disputes. It is known as the UNO test.
UNO.
Yes, the acronym stands for Universally, Necessarily, and Ordinarily Paid.
It's a financial litmus test. If a wage component is universal, necessary, and ordinary for all staff, the Supreme Court classifies it as a basic wage.
It simply does not matter what creative corporate label the HR department slaps on it.
Exactly. And the special allowance introduced in 2012 is paid to all employees universally. It is even paid out when those employees are on leave.
And that specific detail about being paid while on leave creates the most glaring contradiction in the banking sector's defense.
It's incredible.
The courts recognize that the banks cannot selectively decide when the special allowance counts as pay and when it doesn't.
The sources emphasize this hypocrisy perfectly. The banks actually count the special allowance as basic pay when they're calculating leave encashment.
Right.
When staff encash leave, banks treat the special allowance as core salary. But at retirement, for pension and gratuity, they suddenly exclude it, shifting the rules entirely.
They suddenly claim the special allowance is exempt and doesn't count toward retirement.
And the high courts repeatedly dismantle this logic, ruling that an employer cannot have it both ways, depending on which calculation saves them more money.
But because the banks were losing these arguments on a localized state-by-state basis, they realized they had to shift their approach.
Yeah,
Fighting individual battles in Kerala, Uttarakhand, and Rajasthan was creating a patchwork of legal precedents that heavily favored the retirees.
here's where it gets really interesting. The IBA, representing the corporate establishment, executes a massive coordinated countermove. They file transfer petition 133942023.
And this isn't just an appeal of one case.
This petition targets 191 respondents nationwide, pulling scattered regional cases, including West Bengal's Chinmoy Majumdar, into one massive consolidated showdown before the Supreme Court.
It's a classic corporate tactic, turning 21 small local fights into one costly, centralized legal arena where the banks control the venue.
Right.
By bundling these 21 cases into a single transfer petition, the IBA effectively hit the pause button on all the regional victories the retirees had already won.
It forces the pensioners, who are relying on limited personal funds, to fight a highly coordinated battle at the highest, most expensive court in the land.
And keeping track of a mammoth Supreme Court case with almost 200 respondents is practically impossible for an average citizen.
One of the commentators on the subject, Shri Amiya Mishra, breaks down in his podcast the Supreme Court's daily and weekly dockets, giving a sense of the difficult course the case is taking through the court.
Shri Mishraji lays out the current litigation status. As of early March 2026, the consolidated special allowance case sits at item 187 on the Supreme Court's weekly list.
Item 187?
Yes. And it is assigned to Court number 5 under Justices M.M. Sunresh and Satish Chandra Sharma, scheduled for March 11th and 12th, 2026.
But being item number 187 on a weekly list is essentially being parked in a legal waiting room. The Supreme Court of India handles an enormous backlog of litigation.
Oh, absolutely.
A case that low on the docket is unlikely to be heard soon and may sit there for months. Retirees know this delay well. In the video, Mishra recounts a talk with Babu Ram Kashyap.
The same retiree who won the landmark High Court case in Uttarakhand.
Exactly.
Kashyap's role shows the retirees' counter strategy. With the case stuck on the weekly list, they are pushing to join as impleaders to force movement.
Right? An impleader is a third party who formally joins an ongoing lawsuit because their rights are directly affected by the outcome.
By impleading, they can seek an early hearing and push the Supreme Court to prevent banks from delaying the case indefinitely.
The banks use consolidation to slow the momentum, and the retirees use digital coordination to force the issue back into the light. It was basically a war of attrition.
It really is.
Just as we grasp the special allowance fight, a fresh Feb 23, 2026 ruling emerges, exposing yet another layer in how these institutions manage liabilities.
This ruling comes from the Kolkata High Court. It involves a review petition filed by the newly amalgamated West Bengal Gramin Bank.
Okay,
And it illustrates the lengths to which privileged institutions will go to evade statutory employment financial obligations.
because the bank was trying to dodge something known as Section 14B penalties, right?
Under the EPF Act, if employers delay mandatory PF contributions, they are hit with 14B penalty fines.
The statute strictly penalizes companies that tamper with workers' retirement money, and West Bengal Gramin Bank had defaults spanning 1998 to 2013.
Facing fines for over a decade of delays, the bank tried a creative defense, claiming its new 2018-19 pension regulations should shield it.
Wait, years later.
Years later, they claimed their new 2018-19 pension rules exempted them from the EPF Act, using a modern policy as a retroactive shield.
The High Court tore down the argument, noting the defaults were from 1998 2013. A 2018 pension scheme cannot retroactively wipe a decade of statutory violations.
You can't just wave a wand.
Right. A company cannot build a legal time machine out of a new HR regulation. The judge dismissed the bank's review petition outright, upholding the penalties.
Seen in context, the 26 Kolkata ruling captures the hostile environment retirees face. It's the same dynamic the AIBPARC letter flagged when urging the Finance Ministry to enforce honest litigation across banks.
The resource gap is huge. Banks use public money and write off legal fees to endlessly litigate, appeal, and delay retiree payouts.
Because if a bank loses in a lower court, the executives face no personal financial risk in appealing to a higher one. They have the institutional stamina to wait out the clock.
Meanwhile, 80-year-old retirees fund their own defense from dwindling savings, some even borrowing just to stay in the Supreme Court, and aging David against a corporate Goliath.
It really paints a stark picture.
As the Supreme Court held in the Marudhara Gramin Bank gratuity case, these laws exist to protect workers, not to offer employers convenient loopholes.
This raises an important question about the long-term sustainability of trying to outsmart basic wage laws using creative accounting. Eventually, the bill comes due.
It's a battle between the spirit of the law and the cold letter of the spreadsheet. Banks have dragged 191 cases to the Supreme Court. But imagine the terrifying math if they lose.
Yeah, the math is staggering.
If the Supreme Court rules for retirees and mandates retroactive inclusion of special allowance in pensions and gratuity from 2012,
The retroactive part is huge.
how will banks absorb that massive liability, and what shockwave will such a Supreme Court precedent send through industries that reclassify pay to cut retirement costs?
The implications extend far beyond a single sector. It could redefine corporate compensation strategies globally.
We'll be watching court number 5 closely as the justices tackle this ruling.
See you next time. Please comment, clip, subscribe, and share on Facebook.